Good morning. Welcome to the First District Court of Appeals. Today is Tuesday, September 24th. We have 5 cases on our docket this morning. Only 2 are scheduled to argue, but I'll be calling all 5 today. The first case is case number C240211, State of Ohio versus Anthony Wade Thompson, and that case has submitted on the briefs. The next case we have is case number C240129, State of Ohio versus Lucas Cedillo. That case has also submitted on the briefs. Third case, C240148, State of Ohio versus Sean Curry, also submitted on the briefs, so those 3 cases will not be arguing this morning. The following 2 are scheduled to argue. Case number C240063, Chai Chi Ho versus Ross Evans et al. If attorneys can please identify themselves and their readiness to proceed. And I do understand that you are self-represented. So, yes. Good morning.
Good morning, Your Honors. Stephen Ian on behalf of the defendant and appellant.
Good morning. The next case we have is case number C230686, also scheduled to argue. Millie Schaefer versus Sandra Levy et al. If attorneys can please identify themselves and their readiness to proceed.
Stephen Ian on behalf of plaintiff appellant Millie Schaefer on litigation.
Okay.
Good morning, Your Honors. Justin Whitaker for the appellee cross counterclaim defendant Sandra Levy.
Okay, thank you. Okay, so we're going to start off with Ho v. Ross Evans. Ms. Ho, if you can come forward, and this is going to be your table over here. All righty. So, Ms. Ho, you're going to have 15 minutes to present your case. And, so your presentation will be on top of the written brief that you've already submitted. Attorney M is going to have 15 minutes to respond. Now, after his response, you can then respond to his response. So out of the 15 minutes, you can reserve a portion in order to do that. Okay? 5 minutes. So you're going to have 10 minutes for the initial presentation, and then 5 minutes for what's called the rebuttal presentation, all right? Come on forward to the podium. And do you notice that there's some lights there? Well, hold on. Now do you notice that there's a light?
Yes.
That it's turned on, that's green.
Okay.
Okay, so when you get close to about a minute
Okay.
from the end of your 10 minutes, I will turn the yellow light on.
Okay.
And then when your time is done, I will turn the red light on, okay? So you're going to be doing your presentation. We may be asking you questions in the presentation, so, it may be exactly as you've seen it in your head, and it might be a little different, okay? And I know you're nervous, and that's natural, but just, go ahead and, and the goal is to just have a conversation with us, all right?
Thank you, Your Honor.
All right. So whenever you're ready, you can go ahead and get started.
Thank you, Your Honors. May I please the court? This is Cha Chi Ho, pro se litigant, representing the appellant myself. So I want to first thank the judges the opportunity to hear me. You can hear I'm very nervous.
Of course,
As
and it's
in
okay.
my previous appeal in C220319, Judge Kinsley kindly stated, or be my voice, that said, during the past 20 months from December 2020, when the guardian ad litem was first appointed by the court, to August 2022, when the case essentially concluded, which is a divorce case, at the trial court level, the trial court ordered the parties to pay $155,853 to the guardian ad litem for his service. Perhaps given how costly the proceedings below were, Mother represented herself in this appeal, while pro se litigants are held to the same standards as parties who have attorneys. Courts also entertain all cognizable arguments that unrepresented litigants present in interest of fairness and justice, and I appreciate the opportunity to be heard here. I want to fill in a little bit background. There's another appeal prior to this case, which is C-230571 and C-230645. The judgments of the trial court in these two cases were reversed, and the cause was remanded because the record demonstrates that, this is a quote, the guardian ad litem failed to comply with procedural requirement of both Superintendent Rule 48.03H and Local Rule 10.5. And because the trial court failed to provide mother with an opportunity to challenge the reasonableness of the guardian ad litem fees awarded, we hold the trial court abused its discretion when it awarded the guardian ad litem fee in its October 16, 2023 entry. So I appreciate the opinion written by Judge Bergeron. And in this case, here, similar procedural issues were present in declaring me as a vexatious litigator. And I will share three reasons that support my argument. First is about the due process. So as the record present, this case was dismissed. The base of the case was dismissed without the chance for the merit to be heard. There was no hearing for this case. And the opposing counsel filed a motion for the vexatious litigator, and that motion was also granted without a hearing, and it wasn't heard. Any of those...
Did you request a hearing?
As a pro se litigant, I was at a disadvantage.
Sure.
So I did not know how to request a hearing.
Okay.
Also, I was burdened by significant pressure. So at that time, I was dealing with 2 jail sentences from the divorce court. I was dealing with having to pay my ex $500,000 or more, and the guardian ad litem fee of, as you heard, $150,000. And he also requested, you know, about that $16,000 he
Sure.
requested. So
Sure.
I was under tremendous pressure. I can barely survive with such fire from all directions. So I didn't. And but I want to mention there was no finding of any frivolous conduct in this case or any other case. Based on some search on the literature, I think the precedent shows when the litigant was not provided with notice and opportunity to be heard, a remand in appellant review happens a lot, which is all the time, which I can find. Powell and Oliver. And hearing is required to provide a basis to impose sanctions such as vexatious litigator, State ex rel. Tinkler versus Franklin. There's numerous cases for evidentiary hearing was warranted in this vexatious declaration and was remanded, State ex rel. War versus Booth. In addition, the only base is on the appellant's assertion that on the appellee's assertion that appellants brought baseless claims. There was no evidence to support that. And the previous case have suggested the trial court error in declaring plaintiff to be vexatious.
Dr. Ho, is it enough for them to just say that you filed some lawsuits that were not meritorious, or do they have to show more? Do they have to show that those lawsuits were for a nefarious purpose?
Thank you, Judge Kinsley. Indeed, in their motion, they only have a list of the lawsuit I filed, and the base was it was dismissed. So there was no declaration of any frivolous lawsuit. So based on the vexatious declaration, the appellee haven't met the standard. There's no evidence. There's no base other than I filed lawsuit, and some of them were dismissed. Most of them were procedure errors. So there was no frivolous. So I believe their assertion is not supported by the law, the vexatious 2023, which requires frivolous conduct, and dismissal is not frivolous.
And as you mentioned, you have prevailed in some of the litigation that you have initiated coming out of your divorce. How does that factor into the vexatious litigator finding?
Indeed, that is definitely a big factor. The court, especially this court, has repeatedly found reasonable grounds for my appeals and reversed all the appeals. For example, in C-220-391, it was partially remanded. I was wrongfully jailed or sentenced to jail. In C-20571 and C-20645, those were fully remanded. And according to the precedent, declaring a party a vexatious litigator is inappropriate when they have prevailed on their claims, and reserving vexatious sanctions only where zero merit exists across all claims. And this is opposite to the fact here, in which I prevailed in all claims, at least partially. So this is inconsistent with the Supreme Court ruling, in which it have to be zero merit. And I was declared with reasonable grounds and with merits. And across all claims, all my appeal has been remanded. And
Dr. Ho, this is a very fine point of law, the question I'm about to ask you, and so if it's confusing, feel free to ask me to clarify. Whose responsibility is it to show that there is a nefarious purpose for the legal actions that you filed? So is it your ex-husband's responsibility to show that you filed legal actions and they were for a bad reason? Or is it your responsibility to show that you filed legal actions and they were for a good reason?
oh, thank you. This is such an important point. And maybe my answer is not legally correct, but based on my understanding, they have the burden of proof because they are accusing me of being vexatious. So I believe that is my ex-husband's responsibility. And I believe they have not met the responsibility because they have printed out a list of things. First, a lot of actions benefit him because, as you remember, or maybe you recall, all my appeal are related guardian ad litem fees, which could only benefit him if it was remanded, because he paid half of the guardian ad litem fee and I paid half. So there could no way I would be harassing him. Second is the only reason the judge mentioned is I filed several cases and many were dismissed because I'm not a lawyer and can't afford a lawyer at that point. And there's also the third reason is I can't think of it right now.
That's okay, you've given us two very good reasons.
Yeah, I would answer.
And you mentioned a couple times that they did not submit evidence. Like, we have this chart that they submitted, and I looked in the record and I didn't see any other evidence to explain what happened in those cases. Are you aware that they filed anything, or did they not?
I believe I know what happened in each of the case. and-
I know you know, but
Yes.
I'm saying, like, did they bring anything to the court to explain what happened?
The only thing the court sees is their motion, which is that table. There's no other evidence or what was really in each of the cases. But even if they did, the Supreme Court have the declaration in which the court have no authority to, based on previous case, to make decisions. They should base on the information for this case. That's my understanding. So you are correct. They did not bring forward all the details and why those are filed and why those were dismissed. And that is a very strong argument that they have not provided a burden of proof needed to establish the vexatious litigator, which requires, according to Supreme, a very high level of proof because the ability to access the court is one of the Constitution-given right, and they are taking away a significant right. Also, the Supreme Court also declared it is particularly important for a pro se litigant in declaring them vexatious, because that's the whole idea of the court system. That's not reserved to the privileged or wealthy, but everybody should have access. And I thank this court for willing to hear me, which I know I am not as trained.
So I'll give you 30 seconds if there's anything further that you want to say.
I just greatly appreciate the opportunity. I think the question highlight that there's due process violations, and this is inconsistent with this court's opinion. And also, if you can see, since the declaration, I was really harassed, in which I was jailed twice. I was asked for additional $100,000 fees on top of $500,000 already paid, $500,000 legal fees in this divorce case. So I'm the one who really suffer from being harassed and would not want to lose my only right left, which is my voice. I have lost everything. I have lost custody, finance, my job. The only thing I have is my voice. Thank
And
you.
I just want to make sure I understand fully your argument. So basically what you're saying on the vexatious litigator finding is that, that you were simply doing the best to represent yourself with no malicious intent, and that in fact you prevailed on several of your filings.
Yes, yes,
Okay,
yes.
all righty. Thank you.
Your Honor.
Thank you. Good morning.
Good morning, Your Honor.
How are you doing?
I am well. Thank you. And thank you for the opportunity to address the court on Ms. Ho's appeal. I think the first thing that should be recognized here is that the standard of review is abuse of discretion, that the decision of the trial court can only be overturned on an issue like this.
And I
if-
understand that it is a high standard to overcome. One of the arguments this morning was that your client had not met their burden on the vexatious litigator motion. How would you address that?
So I'd address that in a couple of different ways, Your Honor. The first thing I will tell you is that if all of the information about the various lawsuits, et cetera, that Ms. Ho filed is a record of this court. All of the suits were filed in the Hamilton County court system.
Well, let me ask you about that, because I kind of thought that might be your response to this. So, but you haven't shown, like, what happened in those cases. We have the chart, which the trial court relied on, but there's no substantiation about, like, what happened. Is it the court's duty to go out and figure that out? Isn't it your burden to show us?
I think we did to an extent, Your Honor.
But I didn't see any evidence submitted, and I didn't see any elaboration on what actually happened in these cases that would be probative of vexatious conduct.
I think, Your Honor, if you consider the following, it'll perhaps become clearer. First of all, there was evidence pointed out to the trial court in the chart as to the outcome of these various cases. The second thing is that the record also shows that all of this began when Ms. Ho was sued for divorce. She had no record of any contact with the Hamilton County court system until 2021. And at that point, she began this campaign, this relentless
So she basically
campaign.
was defending her lawsuit that was filed against her, and it sounds like you're taxing her for that.
Oh, no, absolutely not, Your Honor, absolutely not. What I'm taxing her for, or attempting to, what the trial court taxed her for, was
Actually,
for-
can we pause there? I'd like to know exactly what the trial court found and what we're reviewing, because the vexatious litigator statute is very specific. It requires at least one of three findings. The first being harassment, the second being no good faith extension of the law, and the third being delay. And we have this chart that the trial court put into its order, and all it says is that some lawsuits were dismissed or are pending. I don't see any finding by the trial court that Dr. Ho filed anything meeting one of those three standards under the vexatious litigator statute. So what are we actually reviewing?
You're reviewing, Your Honor, whether the trial judge abused his discretion if, upon looking at Ms. Ho's litigation history, that the decision that she had exhibited behavior that serves merely to harass, annoy, or embarrass.
How could it be anything but an abuse of discretion when the trial court's order doesn't even meet the statutory standard?
I think it does meet the standard, Your Honor.
Where?
When you say the statutory standard, if the court is asking, did the trial judge's decision specifically lay out a discussion of each of these 11 or so actions that Ms. Ho had filed? No, it did not do that, but I don't think it's required to do that, Your Honor. I think it can look at the.
Well, I think the
evidence
issue
as a
is that
whole.
there was no factual presentation along with the chart, and there was no factual determination by the judge with regard to the required elements for vexatious litigator finding. So the question is, where can we find that? Because it doesn't appear to present itself.
We can find it in a number of places, Your Honor. First of all, we can find it in the statement that Ms. Ho herself made to the Domestic Relation Court, in which she basically stated, straight out, I'm going to keep filing these lawsuits because it's a way for me to make money.
Isn't
to
that
pay what I
taken
owe."
profoundly out of context? I mean, virtually none. I've reviewed these cases. Virtually none of them are for money damages. None of them.
You mean the lawsuits that Ms. Ho filed?
Yes.
Well, that's part of the problem, Your Honor, is that when she files these cases, she doesn't give any detail. She makes one or two conclusory allegations. But she did file a lawsuit against these various entities as the plaintiff, and did so pro se. She did not state a sum that she was seeking, but she certainly was suing these individuals, and she would say things like improper billing, and that's all she would say. And in all of these lawsuits, including this one, including the one that gave rise to this motion, and I, with all due respect, I don't think I'm using Ms. Ho's words against her unfairly here when she made it clear that this was her purpose. I'm filing these lawsuits not for merit, not because I believe I'm owed any money, not because I can prove anything.
But even if what you're saying is true, even if it's true, where does it present itself on the record that we have before us on the issue that we're deciding before us?
So, first of all, we're dealing with an objective standard here. It doesn't matter whether or not Ms. Ho wants to claim that she's not doing it for purposes of harassment. If the conduct serves merely to harass, annoy, or embarrass, then that's sufficient for a finding of vexatious conduct.
And while that's true, there needs to be some facts in order to support that determination.
Your Honor, I'm not sure what that would be other than what this court had in front of it, what the trial court had in front of it.
Well, I think this is the point that you're circling around, which goes back to my initial question.
Mm-hmm.
Like, it's possible that the trial court dug in deep to all these cases and fully analyzed everything that happened.
Mm-hmm.
But we have no indication of that in this entry, and we have no indication of what happened in those cases from your filing. So as we're reviewing this, like, we're not seeing where the substance of these cases was put before the trial court to meet your burden of, by clear and convincing evidence of showing that she's committing vexatious litigation conduct.
Well, if you think about that, Your Honor, when are you ever going to have that? I mean,
Well, when
what
you
would
submit
actually-
a document with exhibits attached and explain, here's the 15 things that she did wrong. That's what you would do to show, you would show the order by the trial court that said she committed frivolous litigation conduct in case X. In case Y, she filed something inappropriately. In case Z, she did this. Like, that's what you would put in front of the trial court judge.
I don't think you're ever going to have that, Judge. I think in order to prove a vexatious litigator, you've got to show a systematic pattern of behavior on the part of the defendant. You're never going to get the defendant to say, yes, I did this for an improper purpose. And in most cases, even if there's frivolous conduct, the parties don't necessarily make a motion for frivolous conduct or make a filing requesting frivolous conduct.
So I want to make sure I understand your argument, okay? Are you arguing because of the voluminous amount of filings that is sufficient to support a finding of vexatious litigator? Is that
Because-
what you're saying?
In part, that's one
Okay.
of the pieces of evidence. First of all, we have the evidence that there was nothing of this nature was going on until she became embroiled in her divorce case.
Well, of course,
with
because
Mr.
she
Coe.
is the defendant on a case that is filed, and now she has to respond to it. So it sounds like you're taxing her for responding and defending a case that was filed against her.
No, absolutely not, Your Honor. What we're talking about here are all these lawsuits that she then files against Mr. Coe, against Mr. Evans, against Mr. Tepe, against Ali Bank, against anybody she can think of for the purpose, as she herself acknowledges, of simply making money so that she can pay what she owes to Mr. Ho.
So let me ask the
And-
question a little differently. Based on the record that we have before us, which is a chart of several filings, are you saying that that suffices, that's sufficient to support a finding of vexatious litigator?
Oh, I think that's more than sufficient, Your Honor,
Okay.
because we don't just have the
So it
chart.
sounds to me as if Dr. Ho had done the same and filed a chart of filings of your client, that would have supported also a finding of vexatious litigator.
My client hasn't engaged in that kind of behavior, Your Honor. He has not been filing lawsuits against anyone he can think of for the past 3 years. The way
Well,
that
hasn't he made filings in all of these cases?
No, he hasn't made, he wasn't a defendant in many of these cases.
Well, he was a defendant in a lot of them, and didn't he make filings in them?
Yes, he made filings to dismiss them, yes, absolutely.
And so we could generate a chart that had his name on it that said that the cases were dismissed in a similar fashion.
But no, he didn't bring those cases, Your Honor. We're talking about cases that were brought by Ms. Ho that had no merit, that ultimately were dismissed, that were,
That's not the standard. The standard is not that people file lawsuits that don't get resolved in their favor. The standard is that there has to be harassment, not a good faith legal argument, or delay.
and Ms. Ho didn't
Which
even...
one is it? Which one is it?
Ms. Ho did not even attempt to make a good faith legal argument in support of any of those cases.
Well, I
How
think
would we know that?
I think one of those cases was one that we found in her favor.
On the guardian ad litem issue?
Yeah.
Yeah,
It's,
and
it's
she-
on this chart, is it not?
Yes, it was on the
Okay,
original.
so then, I mean, how can you make that statement that it wasn't in good faith if she prevailed?
Because I don't think a single success in an ocean of litigation that this woman has filed against innumerable people, I don't think that singular success immunizes her from a finding that she's been a vexatious litigator. And I think that the court can, all of these cases are a matter of public record. It's within the purview of the court and the trial court to review those cases and to make a determination. Hey, look, we've got somebody here who's openly saying, I'm going to keep filing lawsuits just as a way to make money. We've got the fact that all of this only begins, and I'm not talking about appealing domestic relations judgments, which she had every right to do. I'm talking about these constant lawsuits filed against my clients and others.
But
that have been-
appealing the domestic relations judgments are like a third of the chart.
I don't think it's
There's
that much.
four of the 12 line items are appeals to this court.
Yeah, and there's been
So
more.
those aren't like filing lawsuits. Those are appeals, which,
Correct. And there have been more since, I mean, she keeps trying to get the judges disqualified from her case and so on and so forth. And look, nobody is saying that she can't use the justice system. That's what gets lost in all this, is that you can still file a lawsuit. If you have something with merit and you can demonstrate that it has merit, then you absolutely get your day in court. But where you've
And
demonstrated.
although it's beyond our record, I have a question, and I'm curious as to your thoughts on this. Dr. Ho had stated that some of these filings were dismissed because of procedural errors. Do you agree with that?
I think they were dismissed, well, for a variety of reasons. They were dismissed for issues like venue and jurisdiction and failure to state a claim.
And isn't there case law that determines that is doesn't fit under not warranted under the law?
I'm sorry, Your Honor, I'm not following your question.
It's really when you file something that you have no merit for that it could be problematic, is it not? If you file something and you don't pay the filing fees, file it in the wrong jurisdiction, that doesn't necessarily mean that it's not warranted under the law.
Well, under the law means both procedurally and substantively. So I would say yes. If you have a pattern and practice of repeatedly filing lawsuits that are dismissed at the earliest stages because of either procedural or substantive defects, and if you show a pattern of this over the course of several years, and if you state, in fact, in open court that that's your intention to continue to do that, then on the basis of that, yes, I think in the records that are in front of the court in all of the cases.
But counsel,
were
that
cited.
doesn't really square. So on this record, the limited record that is in front of us, what we can see is that most of the proceedings that are being dismissed for procedural reasons are of the appellate nature. And those, by definition, are not going to be the ones for damages. Those are at the trial court level. We do not independently award money here. So that idea that she's somehow filing all of these things to recoup money for herself doesn't square with the idea that she's not following some procedural rule at the appellate level and therefore having her appeals dismissed.
I'm not sure if I agree, Your Honor, because if you consider somebody, forget Ms. Ho for a moment. Suppose somebody just loves filing lawsuits, and they get a kick out of it. And so they...
Isn't that most lawyers?
With present company accepted, yes, Your Honor. But even if, suppose somebody filed 100 lawsuits, and they were all dismissed on procedural grounds, and he never won any of those cases, I don't think that we would say you can't be found as a vexatious litigator because the trial court that kept dismissing all of your frivolous cases never made a finding of frivolousness or did dismiss your cases on the basis of procedural reasons rather than substantive reasons. If you've got somebody filing this torrent of litigation, there's got to be a consequence for it.
Well, and I think, again, this goes back to some of my earlier questions. Like, we've had those cases, and we've found people to be vexatious litigators, but often it's very detailed in the record exactly what they did and the inadequacies of the litigation that, for instance, to your hypothetical, that, like, yes, they filed these, 36 lawsuits, all of which were blatantly procedurally defective, and it's clearly a campaign harassment. But the trial court's making those findings, and then we're able to review that under an abuse of discretion standard. I think that's what's lacking here is any sort of elaboration from the trial court about, like, what actually happened in these cases.
And I simply don't think the case law requires that, Judge.
Okay.
I think it's all of that information is before the court. It's presumed to be known by the trial judge. And in the face of Ms. Ho's, again, I keep going back to this, but her open declaration that this is why she's doing this, I think that gave the trial court more than sufficient ground upon which to make that finding.
And Attorney Im, I'm going to give you 30 seconds if you want to say anything to wrap up.
Thank you. Just the last thing I would say, Your Honor, is, of course, where I began, and that is with the standard of review here. And given everything that we've described about Ms. Ho's behavior and conduct, and the high standard that has to be proven to overturn the trial court's decision, I don't believe that there is a basis upon which to do that. Thank you, Your Honor.
Thank you for your argument this morning. Dr. Ho? So you have your 5 minutes that you've reserved.
Thank you, Your Honors. I just want to thank you. I have 4 points to make. One is the opposing counsel keeps saying I made statement I want to make money. I made zero money. I drained all my life savings to what I love is not filing lawsuit. What I love is my son. I've not seen my son for a long time, for months, years. I mean, I don't have any parenting time. I don't see my son. And what driven this is really as I pull more money to pay the guardian ad litem, attempting to see my son. I lost more money. I got jailed. I lost my job. And that statement was at a hearing about guardian ad litem fees, in which I tell the judge I will file appeal. That's what I mean, lawsuit is if you grant these fees, I will appeal about it because our family already paid about $150 and he won another $20. And just for your information, Judge Bergeron vacated that order for that $16,000 for the guardian, and he refused to return the fees. So instead, he filed motion for another $22,000 trial court, which ultimately get declined, but we still haven't recovered the fees. So what I love is my son. And second point is there's a table that listed all the cases, but what 3 important cases missing is C220319. It wasn't there. The opposing counsel is aware of the remand, but he didn't list it. And another 2306245 and 230571 wasn't listed. Perhaps the judge see that I prevailed in some of the cases, he wouldn't think it's vexatious because Supreme Court have already stated if there's even a single claim that has merit, there's no precedent to declare the person vexatious. And the third point is the opposing counsel mentioned that the statutory standard he used is that I have no good faith. But as you can tell, I make zero money. I put in all my money. I almost get jailed 5 times. And all I want is the thing I value the most in life, which is a relationship with my son. Because of guardian, I feel he kidnapped my son. And I believe I pay him and he will let me see my son. And I apologize, but I was wrong and I want to be heard. So thank you for hearing me. And I just hope from today that innocent person are not declared, whether it's a speeding ticket, whether it's incarceration, they have a chance to be heard. And in this case, it's a vexatious declaration, which is particularly important because everything has been taken away from me. My liberty, my child, my finance, reputation, job, everything. And lastly, I want to thank you, and perhaps I'm not an expert, but I believe the standard review for this case will be de novo. Because as I look up the case, the de novo standard of review applies to determine questions of law in appellant review. Appellant court will review whether the judgment was supported by the weight and sufficiency of the evidence as a question of law. And here, there's just no evidence, not alone the weight or sufficiency. In addition, there was intentionally omitted evidence of the success in the appeals court. So I believe the standard is not quite abuse of discretion. And I just want to thank you, and I apologize not being trained.
Thank you. Thank you. You have nothing to apologize for, and you have nothing to thank us for, because it is our duty to do our job and to do it properly, okay? Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and we wish you both a wonderful afternoon, although I recognize, Attorney Im, that we still have some more time that we will be sharing with you. Thank you. Good morning. So now we have Schaefer versus Levy. Attorney M.
If I may, I'd like to reserve 3 minutes for the rebuttal.
Okay.
May it please the court. It seems strange to be in this position, talking about a woman against whom a default judgment was entered, when that woman for 4 years, Millie Schaefer, who's in the court today, that woman for 4 years had diligently responded to every pleading and motion that concerned her. When we think of a person in default, we think of a person who is ignoring their responsibilities to the court, who doesn't answer a summons, who puts their head in the sand, and who does not participate in the litigation. What we're talking about here in Ms. Schaefer is a woman who participated diligently and consistently in this litigation to defend herself from any and all claims that were made against her. Now, the basis for the default was my client not filing an answer to a second amended complaint.
Counsel,
Yeah.
how do we fit the May 16th and May 23rd filings that Ms. Schaefer made to respond to the abusive process claim into the 60B framework? So what specifically, I know in your brief to us, you've alleged 60B1 excusable neglect. So what exactly is it that she neglected? And then why is that neglect excusable?
Well, the first thing that I would say is that the court doesn't even have to get there. I don't think the court even has to look at the Rule 60 issue, because Rule 55A specifically says that if somebody has answered or otherwise defended the case, then you can't even file for a default. And the cases
Well,
from this...
counsel, can we unpack that for just a second? So the notice of appeal was filed out of time to reach back to the default judgment itself. So the only way we could do that is if there's a jurisdictional issue in terms of the default judgment, right?
Well, no, because I think the default judgment wasn't a final judgment. It didn't dispose of all of the claims in the case, and it did not contain the no just reason for delay language.
Well, your notice of appeal is specific to the 60B order. It doesn't purport to appeal the the Rule 55 default judgment.
Well, they're connected in the sense that Rule 55 specifically says that a default judgment can be set aside under Rule 60B.
Right, so 60B is the vehicle, so we've got to tether it to something in 60B, and you've argued in your brief it's excusable neglect. So can you walk me through that argument?
I will, Your Honor, but I would say that Rule 60B is a vehicle. I don't believe it's the sole vehicle. And I believe that this judgment was void ab initio. And in fact, the cases from this very district have held repeatedly that a judgment like this is void ab initio.
Are you referencing the plant equipment case?
Yes, yes. And so, it can be attacked at any time. But yeah, if we want to go to what I think is the second step of the process, and that is, all right, first of all, setting aside the issue of whether or not the court even had the power to grant a default judgment against somebody who clearly was not in default. If we then say, all right, should the court have granted the 60B motion on the basis of excusable neglect? The answer to that question, I think, is also yes, because the excusable neglect is entirely understandable under these circumstances.
What was neglected? So let me just lay this out for you. I'm struggling a little bit with this because I think there's a little tension here. What I'm hearing you say is that the May 16th and May 23rd pleadings were sufficient. They contained a response to the facts, they challenged the ulterior motive element, they set forth a statute of limitations defense. These were, for all intents and purposes, answers. They were responsive pleadings. So nothing was neglected. In fact, she did everything she was required to do. So how does that fit within the excusable neglect piece of 60B, given that your argument is essentially she didn't neglect anything?
I think it's excusable neglect on Ms. Schaefer's part, that she didn't understand that the trial court was going to violate Rule 55 and grant a default judgment when there hadn't been a default. So I think she had the reasonable expectation that her pleadings would be acknowledged and that she would have the opportunity to have her day in court on these claims.
But what did she neglect?
She neglected to understand what the trial court was doing.
Did the trial court provide her specific notice of its intent to potentially enter the default judgment?
So the trial court ruled, no, it didn't give it an extent. I don't believe, Your Honor, that it specifically said to her, you're going to have a
Because
default.
Rule 55A says if a party has appeared in a matter, 55A I'm sorry, I'm reading one of the cases. 55A requires that notice be given to the party. And so that's my question, like, did that procedural step happen?
No, I don't believe it did, Your Honor.
Okay.
He told her, or the judge said, gave her 14 days to respond to the Second Amendment complaint. She filed the next day a motion for summary judgment, and a week after that, she filed her opposition to the Second Amendment complaint. I'm willing to be corrected on this, but I don't believe that, I know the judge never said we're going to have a hearing on the motion for default judgment, which it absolutely had a duty to do. And again, the cases from this circuit have been foursquare on that issue, that in the absence of a notice, a written notice, and at least 7 days prior to the hearing, in the absence of that hearing, then it's an abuse of discretion for the court to grant a default judgment.
What's the appropriate remedy if we were to agree with you that the judgment is void because there was no hearing? Is the appropriate remedy to remand for a hearing, and would that just produce the same outcome?
No, I think the appropriate remedy, Your Honor, would be to find that the default judgment is overturned and the case is remanded to the trial court for further proceedings. Within the court's ruling, it should hold that Ms. Schaefer was not in default. We find that Ms. Schaefer was not in default in this action, and therefore the entry of default judgment against her was inappropriate. And so the case is remanded, and then at that point, I believe Ms. Schaefer is entitled to get a ruling on
Do we
the
have
motion.
jurisdiction to reach that finding? This is a very nuanced question, but if we're reviewing what is in essence, under this hypothetical outcome, a void judgment, then do we have jurisdiction to reach a merits-based holding
A merits-based holding on the merits of the...
that she was not in default?
Yeah, I think you have jurisdiction to do that.
How is that?
Because, again, it's a void judgment. It can be attacked at any time.
But if it's a
Make that
void
list.
judgment, then how can we go the next step and say, and also it's incorrect on its merits?
I'm sorry, Your Honor, I must be more obtuse than normal this morning on that.
Let me try to unpack it further, and thank you for letting me know that my questions are not clear. If the underlying default judgment is void, meaning that it's a nullity, it never occurred, it never took place, how can we then review something that never took place and say it was improper? Because the concept of making it void means it never happened, right? It
Right.
didn't occur.
Yeah.
So if we were to review something that didn't occur, we would be going outside of our scope of review.
And maybe the issue is it's not void ab initio. Like, I think that term gets thrown around a lot, but like from what you're describing, it's not something like without jurisdiction. It could be something that the trial court was incorrect on, but that's just something that gets challenged in the ordinary course, like any other alleged error by the trial court. So is it void ab initio, or is it just, or maybe we just need to move away from that language?
Yeah, yeah. Perhaps it would be best to move away from the language. I think the language that the First District has used in the cases that we have cited the court to is very clear that there can be no default when somebody has entered an appearance in a case. There can be no default without a hearing.
And it seems like you're interpreting that as void ab initio, meaning that the court didn't have jurisdiction
Right.
to make that entry, as opposed to the court made that entry outside of the law.
Right. I think that's correct, Your Honor. Yeah, I think that the court does have the ability to look at this from two perspectives. Number one, you entered a default judgment against somebody who clearly was not in default. And secondly, I mean, to your question, Your Honor, about, well, I see that my yellow light is on, so unless the court has other questions, I'll reserve the rest of my time.
Okay, all right. Thank you. Good morning.
Good morning, Your Honors.
How are you
First of
doing?
all, I apologize. I lost my voice last week, and I'm going to do my best to find it.
Okay, too much partying, huh?
Yes, that was it. May it please the court and opposing counsel, I heard opposing counsel say that maybe we should back away from the void ab initio language, and he's absolutely right. For the reason that the plant equipment case was distinguished rather directly along similar procedural steps and facts as this case in the Abbott v. Ford Development Corporation case 12 years later, 2015 Ohio 5233 is the First District case. That said that if there's no hearing on a motion for default judgment, it's not void if there's no prejudice. And that's what happened here because
How could there not be prejudice if you're getting a default judgment entered against you?
because it wasn't a final judgment, Your Honor. It wasn't a final default judgment until there was a hearing on damages. And
But doesn't there,
Which is
in
what-
this circumstance where the party has appeared,
yes.
doesn't there have to be a hearing on the front end before the declaration of default?
What the Abbott case says, Your Honor, is that all there has to be is notice of a hearing. And there was notice of a hearing on June 2nd, Friday, June 2nd.
Notice of a hearing on the default judgment?
The Abbott case says that there doesn't have to be an oral argument, there doesn't have to be an evidentiary hearing, there just has to be a hearing as to how the court, in its best judgment, would hold a hearing. So on June 2nd, in answer to your question earlier, the court gave notice that it was going to enter default judgment. The parties appeared on June 5th, which was the first day of trial, to discuss that issue, and the judgment was not entered until after that hearing. Ms. Schaefer was present, counsel, I was present.
So you're saying, and forgive me if I've got the dates wrong, but you're saying the default judgment was not entered until after the June 5th hearing?
It was entered on June 5th after the proceeding in the morning of June 5th, yes.
Okay.
Was that the trial, or did something else happen
There was a
on
hearing
June
in the
5th?
morning. There was a hearing in the morning.
Separate
before
from the trial
Yeah, separate from the
itself?
trial. The trial proceeded after that.
What was that, what happened at the June 5th hearing?
It was just a discussion of the default judgment. And that was entered after that discussion, and then there was a discussion on the record about, and then in a later order.
What was the discussion? Like, was there argument, was it a typical, like, motions hearing?
It was not. There was, everybody was there to give argument to give their perspective to Judge Branch because she had not entered the order yet. She entered the order after that hearing on June 5th, and then the parties agreed that there would be a hearing on damages on August 4th.
Okay, can I rewind for a second?
Yes.
So on June 2nd, which I believe was a Friday,
was.
and then June 5th is Monday, and the trial was supposed to start on June 5th, Monday.
Correct.
On June 2nd, she sends notice out to the parties, I'm going to grant the default judgment,
Yes.
which I assume is to enable the parties to be prepared for the Monday, June 5th trial, because that claim is no longer going to be part of the trial because the default judgment is being granted.
That was the note, that was the notice that was sent out. It
Yes.
was not an order that was entered.
It's making everyone aware.
Making everybody aware, and then there was argument that morning,
Where
briefly.
the parties could say, Ms. Schaefer could say, don't grant that because
Yes.
whatever her reasons were, and you could say, no, grant that because here are my reasons.
Right. And it was very brief. I'm not saying it was a full-blown evidentiary hearing or an oral argument. The Abbott case says you don't have to. The Abbott case says if there's no prejudice,
And was there notice that was sent out? So did that June 2nd notice that the judge intended to grant the default judgment, did that include some kind of statement that there would be a hearing on June 5th? Or
It
the
did not.
issue would be taken up then?
it did not say that. But
It occurred organically in the nature of, like, we're getting ready for trial, so let's take up this issue and that issue.
well, she said everybody, she said it'd be here in the morning. The trial started, if I remember correctly, the trial started just before or just after lunch. So we discussed this in the morning at 9 or 10 o'clock. And she reiterated, okay, I'm gonna enter the judgment. And she did so later that day. I got to get back to the Abbott case, though, because the Abbott case says that when there's no prejudice, there's no harm, no foul. It's not void. And there was no prejudice because there was actually two more hearings. There was the damages hearing that Ms. Schaefer had notice of, and it was an agreed date. And then the same arguments that would have been presented at a oral argument or evidentiary
Well,
hearing.
isn't the prejudice standard focused on whether Ms. Schaefer ultimately could have defended the claim?
She could have defended the claim had she filed a responsive pleading. She didn't file an answer. She didn't file a Rule 12 motion. She filed a motion for summary judgment, which is not a responsive pleading.
What do we do in the prejudice calculus with the fact that she has raised, and I don't want to put any terms on it, but she's presented some arguments about the ulterior motive piece, about statute of limitations. They may or may not be meritorious, they may or may not ultimately carry the day, but she has presented some arguments. How does that affect the prejudice
It
analysis?
doesn't affect the prejudice analysis directly. It affects the 60B analysis, because that speaks to whether or not there's a meritorious defense. So if there's a meritorious defense, then you go to the 60B analysis.
Well, how do we know that she wasn't prejudiced if she's claimed that she has some defenses? Is there anywhere that we can look in the record to understand whether those defenses would or would not have been meritorious?
The court could look to the transcript of the 60B hearing in which none of these defenses were raised. You can look to the 60B hearing in which Judge Branch 3 times implored opposing counsel, would you like to have an evidentiary hearing? It was declined 3 times. It was waived. Mr. M said, it's not necessary, it's not needed, it's not required. That discussion, that any evidence, any facts that would have been presented at that hearing would have been a defense to the motion for default judgment.
All right, so your position is that she could have come forward at the 60B stage and essentially defended the claim there?
That was essentially the remedy, because under 55A, if a default judgment is entered, your remedy is to go to 60B under one of the 5 factors and identify a reason why default judgment should be overturned. So that was essentially the same hearing.
Would that have been a mini trial in essence? So like with
Would have been-
flipped burdens, so then she would have said, like, they can't prove ulterior motive and there's a statute of limitations problem and here's all my evidence to that. And then you would have said, wait, we can prove ulterior motive and the statute of limitations is met and here's my proof, and it would have been like a mini trial?
No, Your Honor, she didn't have to prove a defense. She had just had to demonstrate that a defense was possible. She didn't have to prove her claim. She didn't have to prove a defense. Ms. Levy didn't have to prove her claims either. She needed to bring something, some facts before the trial court to suggest under 60B1 that there was excusable neglect. 60B5 is the catch-all for extraordinary, unjust situations, which wasn't really argued. And this wasn't one of those situations. But under 60B1, that issue wasn't even raised until the 60B reply brief. So it was waived then. It was waived at the hearing, when a hearing, an evidentiary hearing, was specifically declined. And the only information, the only facts given to suggest excusable neglect was that Ms. Schaefer is pro se, and she didn't understand the process.
Do you have a perspective on what she neglected? Set aside whether it was excusable, but do you have a perspective on what was neglected?
Yes, Ms. Schaefer didn't file a responsive pleading within 14 days.
And so you do not interpret either the May 16th or May 23rd pleadings to be responsive in any way?
I do not, and there's not been any argument. There was never any argument below to support that. That the time for that argument could have been at the 60B hearing, which Judge Branch at the top of the hearing said, I'm going to let you guys argue whatever you need to argue. If you want a hearing, you can have a hearing. If you want oral argument, you can have oral argument. But she said her practice is everybody gets to have their say. And she invited everybody to have their say and to make their arguments, and none were made. After an evidentiary hearing was declined, by my count, 3 times at that proceeding. So there was nothing at that time to show excusable neglect or to show a reason to overturn the motion for default judgment when Ms. Schaefer was represented by 2 attorneys.
What was the substance, and I don't have it in front of me, the substance of her, I think, summary judgment filing in response to the Second Amendment complaint?
I don't know, Your Honor, and I don't think Judge Branch did either. I think that she expressed that, and I don't want to put too fine a point on it, but Judge Branch expressed she asked whether or not she's supposed to interpret gibberish as a responsive pleading. And again, I don't.
Counsel, I mean, I've read it. I wouldn't call it gibberish. I mean, she does say that the ulterior motive element isn't met, and she does push back on the motion for leave to amend and the timing of that, and that the trial's coming up. And she does say that it's more than 4 years after the fact, and that she feels like it's too late to be bringing this claim, which resounds of a statute of limitations claim.
And that was within the trial court's discretion whether or
What
not.
if she had just changed the label from summary judgment to motion to dismiss? Like, then we wouldn't be here, right?
Well, we would be here if it's, I mean, we have to look at the substance.
But whether it's a meritorious motion to dismiss or not,
Sure.
that would then be a response to a complaint.
If there was a 12B motion
Right.
filed in response.
And so what my question is, if she had just changed the label of that from summary judgment to motion to dismiss, would there be a basis for default judgment?
If it had just been changed, the label had just been changed? No, there would.
And why not?
Because
Why
there
not?
would have to be, you would have to present to the court a basis under 12B.
But
You'd have to.
well, but you're again saying, you're suggesting that the 12B has to be meritorious. Like, I can file a 12B motion that's completely frivolous, but I'm not in default.
You're right, Your Honor. I'm not saying that the 12B motion would have to be meritorious.
Right.
It would have to be recognizable as a 12B motion, though.
I
And
think-
Judge Branch did not recognize it as such.
I think the heart of Judge Bergeron's question is form over substance.
Sure.
And there's a lot of case law to support that
Sure.
it's really substance that's going to prevail
Sure,
as
and this-
opposed to form.
Right, and the
So,
sub-
so the question is, or why isn't this just putting form over substance?
Because Your Honor, there has to be a little bit more, just because Ms. Schaefer is pro se, and this was brought up repeatedly, there has to be something in the motion to recognize it as a 12B motion. Not just the label, but there has to be something substantively in the motion to say, this is a responsive plea.
Well, but I think that's where I get back to what Judge Kinsley was reading or adverting to is, I think your claim is bogus, right? Like, that seems to be the tenor of the motion. Like, I mean, isn't that essentially what we're saying? We dress it up in lawyer speak, but that's what we say in a 12B6. Your claim is bogus.
That is what we say,
Yeah.
but the trial court did not recognize it as such. The trial court
But I think
recognized.
that the question really isn't whether the trial court recognized it, the question is whether the trial court should have recognized it.
No, I don't
Whether
think,
we're putting form over substance.
I don't think the trial court did that, Your Honor, because Judge Branch had been sitting and presiding over this case for 3 or 4 years at that point, and she knew the parties and she knew the management of her docket better than anybody else. That's why we defer to her discretion when handling the docket. And she's not one to just flippantly say, this is not a 12B motion, therefore I'm going to elevate form over substance here. She looked at the motion in her order. She looked at it and did not recognize the arguments as being responsive pleadings. And this is an abuse of discretion standard. There has to be some finding that she went so far out of the law or out of her jurisdiction that the order itself was unlawful, essentially, or unconscionable, and that's not here.
You have about a minute.
Okay.
Just letting you
And
know.
nor was any of this brought up at the 12B or the 60B hearing. Once Ms. Schaefer had secured attorneys, presumably these things would have been brought up had they had some legs, but they weren't discussed. They weren't discussed in her 60B motion, if at all, until the reply. There's plenty of precedent to say that if you can't just bring up new arguments in the reply. There was nothing at the hearing mentioned about that. There was no issue of excusable neglect factually brought up at the hearing, even when Judge Branch begged for facts. I think had Judge Branch been given some factual basis to show that the default judgment wasn't warranted, she would have done it. We discussed that on the record, that had Ms. Schaefer properly responded to the motion for default judgment, I think I conceded on the record to Judge Branch that the court would presumably have not entered default judgment. So she took very seriously, she looked at it very seriously and found it lacking.
Counsel, can I ask a procedural question?
Yes.
It's my understanding that the remainder of this case proceeded to trial to essentially no findings, like the jury held that no party sustained its burden of proof on any of the claims.
Yes. Without Ms. Schaefer, or Ms. Levy wasn't a participant. She was there as a witness, and that was it.
Is the rest of the case over? Is this the last piece of the case?
This is the last piece of the case other than a 23-2351 motion, which is, in part depends on some privilege issues that the court ruled on earlier this year. So there's this issue, and then the expectation that possibly the Supreme Court will take that back up, and then eventually, hopefully, get back to the trial court. So.
And that is between these two parties, not the landscaper?
Correct. The landscaper is
out. Okay, thank you.
Thank you for your argument this morning.
Thank you, Your Honors.
I can't get past this sort of Alice in Wonderland world in which somebody like Mrs. Schaefer, who has been, participating diligently in a piece of litigation for 4 years, who filed not one but 2 pleadings in response to the second amended complaint, who filed a response to the motion for default judgment, one of 2 motions for default judgment, by the way, that were filed within about a week of one another by the defendant. This is a woman who was defending herself against a literal onslaught of motions and replies and briefs that were being filed on literally almost a constant basis. Ms. Schaefer is there every day. She's appearing at every hearing. She's responding to every single pleading, every single one. And yet we're here because she was found in default. Not because she lost on the merits. She was found to be in default. Are you kidding me? This woman, everything that she did in this case, she defaulted. She deserves to be treated like somebody who ignored her obligations to the judicial system? Nonsense. Nonsense. And even greater nonsense is this notion that somehow, kind of, sort of, maybe if you squint and you forget what you had for breakfast, you can say that we had a hearing that's required under Rule 55.
Well,
So-
counsel, did she get notice of that? Was there any notice sent out that the issue would be taken up on the morning of June 5th?
No, Your Honor. No, there was not any notice of that. There was no,
And I also find interesting that what opposing counsel said was that if there was notice, it was given on Friday, that it would be presented on Monday.
right. And this court, of course, is bound by what's in the record. And the record does not show any notice being given to my client of a hearing on a default judgment. And let's remember, too, what the purpose of that.
How would you characterize what occurred on the morning of June 5th?
On the morning of June 5th, I would characterize it as a pretrial conference. The case was about to begin, and the court, during the course of that discussion, announced that it was granting, or it said on the 2nd that it was granting the motion for default judgment. There had been no hearing up to that point. There had been no notice of the hearing up to that point. And the purpose of that hearing is not evidentiary. The purpose
What
of
was
that.
it that was issued on Friday?
What
Was there
issued on
anything,
Friday?
as I understood from opposing counsel, there was a notice sent out on Friday
Yeah,
that the motion will be heard on Monday, and that made sense because that was the day that it was scheduled for trial, and thus there was nothing to necessitate the trial by ruling on the motion, and that the trial court had sent notice. This is as I understood the argument, that the trial judge has sent notice that the motion would be either heard or granted on Monday.
first of all, even if that occurred, it's illegal, because my client has to be given 7 days' notice of a hearing on a motion for default judgment.
And that's in
Second-
Rule 55, the
Right.
7 days?
Yes, exactly. And so she never received notice of that. There's nothing in the record to indicate she got notice of a hearing. There's nothing in the record to indicate that any type of hearing was scheduled. And again, the purpose
And you're
of
saying
it-
even if there was, it's outside of the requirements because it wasn't within the 7 days?
Exactly,
Okay.
exactly right.
Can you address the prejudice argument being made by opposing counsel that even if there's some technical noncompliance with the Rule 55 notice and hearing requirement, we are to excuse that in the absence of prejudice to Ms. Schaefer?
I can't imagine anything more prejudicial to Ms. Schaefer than having a default judgment.
Well, I think his argument was that when Judge Branch was saying, like, do you guys want to do anything? Do you want to present any evidence, that you said no to that? So I think that's the issue is, did you have a chance for a hearing and say we don't need a hearing?
No, absolutely not, because first of all, the default judgment had already been ruled upon by the time we made our motion on behalf of Ms. Schaefer to set it aside. So that what the judge had already done was wrong, and the motion had already been granted without a hearing and without notice. So I don't think Ms. Schaefer needed an evidentiary hearing at that point, and that's not the hearing that Rule 55A contemplates. Rule 55A contemplates a hearing where somebody has been participating in litigation and has been defending themselves, or has at least made an appearance in the litigation. The courts say, right, Rule 55 says, if you're going to render a default under those circumstances, then you've got to give notice, because this person was here at least at one time, this person entered an appearance. We want to hear from, we want to at least give this person an opportunity to be heard. Why didn't you respond to this pleading? What was the reason that you didn't say, file an answer, whatever?
Recognizing that you have a brief amount of time left, I would like for you to address the argument on the Abbott case on prejudice. How would you address that? Because what I would like for you to address specifically is, what does prejudice mean? What is the application of prejudice?
Yeah, I'm not sure that I'm prepared to answer that, Your Honor. I do know that the Abbott case overturned the default judgment that had been granted in that case, and did so on the basis of the 7-day requirement.
It just seems to me that oftentimes the application of prejudice amounts to that there was no like in this case, no cognizable defense. And so there's no prejudice because there was nothing to begin with. But what's being presented this morning is a different application of prejudice.
Well, if I'm understanding Your Honor's question, I think that one of the important points is that the person who makes the Rule 60 motion is not required to prove their meritorious defenses. They're simply required to show the court or announce to the court that, yes, we do have meritorious defenses, and here they are. And in our motion, Rule 60B motion, we supplied what those defenses were. Again, this was an
And the
abusive.
trial court made an express finding in resolving the 60B motion that Ms. Schaefer presented colorable defenses, correct?
Correct.
So would you say that a situation where there were no defenses at all, that there would possibly be no prejudice?
I suppose in that circumstance.
Okay,
Yeah.
which is, you would differentiate, obviously,
Yeah, yeah.
your case
Yeah,
to that.
what we
Yeah.
have here.
All right. I don't know if there's anything further from the panel. Okay, wonderful. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. We thank you both for your zealous representation and your presentation this morning, and wish you both a wonderful afternoon. And that concludes our hearings for this morning.